Hello, welcome everybody to another episode of Cherry Bekaert's Technology Industry Podcast. My name is Chris Del Cambry, a tax partner here in the Cherry Bekaert office based in DC, C Corp specialist, and today I'm joined by Raj Tripathi, a managing director in our international tax practice. Thanks for joining me today, Raj.
Thank you, Chris, and glad to be here.
Raj, for the listeners, why don't you give a little bit of background? Your background is extensive, especially with international. So I think it'd be good to hear exactly kind of your qualifications and expertise.
Absolutely. Thank you. And Chris, I have been doing U.S. international tax outbound, inbound for last 25 plus years, helping any U.S. global clients do their global expansion, tax due diligence structuring, U.S. international tax compliance, or any foreign companies coming into the U.S. and what are the U.S. international tax issues. That has been my expertise for the last 25 plus years. And since 2008, I'm also leading the U.S. India corridor for my prior firms coming from the Big Five and now with Cherry Bekaert, where we help our U.S. clients who are trying to expand, set up their back offices or R&D centers in India. Primarily, we help and support them, and also any Indian companies that are doing expansions or looking at supporting the U.S., we help and support them from U.S. inbound perspective.
Yep, and I've worked with you personally, Raj. You definitely know your stuff and a great resource for Cherry Bekaert, great international tax specialist. Just again, so Raj and I are here today. We're continuing the conversation in a short series for Cherry Bekaert that's focused on international tax matters affecting technology companies. Specifically, we're going to touch today on the employee resources and also how the entity structures roll into that, and some common terms you'll hear today are some important kind of definitions. And if you haven't heard them before, we'll go through them. But you'll hear a lot about inbound versus outbound companies, or inbound versus outbound transactions. And another term you'll hear a lot of today is permanent establishment, which in the industry a lot of times is referred to as PE. High level, if you've heard these before, outbound, inbound, permanent establishment, the initial understanding of those terms isn't super complex. But again, if you've never heard those terms before, I think it'd be wise for us to kind of just level set for the audience and discuss what that means. And Raj, I can't think of anybody better to give us the definitions for those or kind of go over them briefly. What can you kind of break down for the listener and just as a starter, the inbound versus outbound, and then roll into permanent establishment for both as well?
Absolutely. So Chris, there's three terms that you mentioned: outbound, inbound, and the permanent establishment, which I will acronym as PE, is a very three terms that is always used in the U.S. international tax outbound, inbound services. Just keep in mind that U.S. has tax treaties with almost most of the countries in the world. So when we talk about outbound, what that really means from U.S. international tax perspective is that any U.S. company, corporation, partnership, individual, trust, when they are looking at setting up a foreign subsidiary, a foreign branch, or trying to invest into a foreign company, so they have to start thinking about that. Hey, I'm going to go in a foreign country, set up a partnership, a joint venture, a corporation, a subsidiary. What should I do from my global expansion perspective? And what are the things that I have to consider from US international tax filing perspective and tax rules perspective in the US, plus the treaty, the tax treaty that US has signed with most of the countries across the globe. So that's something that you always have to keep in mind, that that's more outbound, a US company going outside the US to do business, set up operations, acquire, hire employees and consultants, set up their legal entities. In addition to that, they also have to keep in mind that the US international tax rules always say that any US company, individual, corporation, partnerships, JVs, they have to report their worldwide income in the US, and that triggers a filing requirement. The companies will have to make sure that when they file the US federal return, they also have to file the US international tax return. That does get triggered, which could be if you have a subsidiary, then you have to file a Form 5471. If you have a partnership, you have to file a Form 8865. If you have a subsidiary where you check the box is a very US concept, where a U.S. company can go set up a foreign subsidiary or not per se corporation and check the box on that entity to make that as a flow through or a partnership or a disregarded entity for U.S. tax purposes. So that's something that you have to make sure that you are complying under the US tax regulation by filing those returns along with your US tax returns. In addition to that, you also have to keep in mind that the US, as I mentioned earlier, has a tax treaty with most of the countries. What that really means is that anytime you are doing business in a foreign country, are you looking at maybe hiring consultants, employees, and will that trigger a permanent establishment for you in that local country? And therefore, there's a tax treaty that says Article 5 of the tax treaty, which is part of the OECD, standard tax treaty, say that if you're going to a foreign country, establishing of any kind of a presence over there without a legal entity, then that could trigger, a permanent establishment. In addition to that, there is also withholding taxes that gets triggered, and the foreign tax credit that you can claim because of the double tax treaty. If you have an operation in a foreign country and you're paying taxes in a foreign country, and when you report that income into the US, you don't want to get taxed again into the US. So therefore, to avoid the double taxes, the treaty will help you analyze that what kind of credit can you claim in the US on the taxes that you have paid in the foreign country. And whenever you're bringing your profits, like your dividends, rents, royalties, your capital gains, your royalty, what kind of withholding taxes are being paid in the foreign country when you bring that income to the US, and can you claim a foreign tax credit on that withholding tax is also where a tax treaty will help and benefit you. So that's more from the outbound perspective. Let's switch our gears on the inbound. So when we talk about inbound, it is something a similar concept, but it's more about a foreign company that is looking at doing business in the US, and they're looking at, hey, I want to set up my operation in the US, set up my legal entity, or hire consultants in the US. So that's where they will have to start thinking about, how do I do business in the US? What are my options available? Whether I should come to the US by setting up a corporation, an LLC, a branch, a partnership, and also keep in mind there are 50 states in the US. So then the foreign company will have to analyze, should I set up which state is more beneficial for me? Which state is giving good credits and incentives? Or what is my good plan to exit out of that state if I set up my footprint in the US? So we have to keep in mind that you have to consider your federal tax issues, your state tax, and based on that, whichever state is giving you the best income tax rate, you try to set up your operation in that state. So that's from inbound perspective. But also keep in mind that the foreign company, when they're doing business in the US, they also have to consider the different filing requirements from federal tax perspective, state income tax perspective. They also have a sales and use tax. They have to consider international tax. They have to put proper transfer pricing in place. And also there are certain states which will tax you on there'll be franchise tax, there'll be city tax. Some states do levy that. So keep in mind all those taxes needs to be considered before you do your business into the US. That's more inbound perspective. The last thing over here that always any company that goes outbound or inbound needs to keep in mind is the P, the permanent establishment that you had mentioned, Chris, earlier. And this is something that we have to keep in mind when doing business outbound or inbound. So what P, it's basically an international tax concept, which means a company or a business could be subject to tax in a foreign country where they are performing or conducting business without having a legal presence. There are few, as I mentioned earlier, there are few common types of P exposure under Article 5 of the tax treaty, standard tax treaty that US has with most of the countries. And those are basically fixed place of, fixed place P exposure, your and if let's say you are high, or you're looking at service P, or you have some kind of a dependent agent or independent agent exposure. So we have to make sure that those concepts are analyzed properly to make sure that there's what kind of P risk is there when you're doing business in a foreign country. In short, I would say P is creating a taxable presence by a corporate outside its territory. This is also an important concept for any corporation that is overlooked when companies are planning to expand globally by hiring consultants in a foreign country to export goods or providing services without having a legal entity. So this is more of a tax language that I'm talking about, but keep in mind that if a company does not understand the P issues or the concept of P when they're doing business outbound or inbound, there could be a tax, in addition to tax, there could be a legal issue as well, that they need to consider.
Yes. And thank you for that, Ron. I know I said maybe if you know these terms before, it's not super complex, but maybe that's not true. Maybe we're a little bit more complex than we thought. So let's break that down a little bit more. Let's start with the outbound. And just because I think personally that the outbound is a little bit of an easier topic, and then selfishly that's usually what we see the most of here in the DC market. Although we do have the inbound as well. But starting with the outbound. Maybe an example is good here too, Raj, because I know you and I personally work on a company together. It's a US-based company, and they recently took on some direct hire employees in a foreign country, or maybe what some people call "quote unquote" W-2 employees. Unfortunately, we weren't part of that planning early on, but luckily we were wrapped in before this went too far down the road. Maybe a good way to talk about outbound here, Raj, is if you could maybe explain the problems we encountered there, and then generally what a U.S. company, a U.S. parent-based company, direct hiring employees in another country could mean from a U.S. tax perspective, and then also from a foreign tax perspective.
Absolutely. So the question here is like, let's say, for example, that one of our clients that we are working together has hired employees in a foreign country, and those employees are, for a US payroll perspective, they're W-2 employees. So when you go ahead and hire an employee in a foreign country, we have to make sure that we are doing a proper due diligence, understand the roles and responsibilities. What is the kind of job that person is going to do, that individual is going to do in the foreign country? What services that person is going to render? Is it going to be sales and marketing? Is it going to be doing software development? And all those services that the employee is going to render, is that falling under the ancillary and auxiliary definition? And can we mitigate that? Hey, because it is ancillary and auxiliary, there is no P risk, So that's where we'll have to first do a proper due diligence. Now, the second thing we have to keep in mind is whether the individual will be working full-time or part-time. That's equally important. A lot of companies will hire a consultant in a foreign country that'll work maybe 20 hours or some 40 hours. So that's something that we need to really understand, that what is the person really going to be working on full-time or a part-time basis, because that could construe that the US entity is hiring a dependent agent or an independent agent. So that analysis and due diligence is equally required. Then the third thing we need to start focusing on is that the country should think about, hey, what is my treaty with that country is talking about under the Article 5? What services will trigger a P for me? Sometimes they will have dependent agent, independent agent, business service income. They will also have service P that gets triggered. So going and back and doing that due diligence and understanding the services that there's going to be rendered, and whether that triggers any kind of a P for me, a service P or a dependent agent P, or a fixed place P will get triggered or not. And we also have to understand that we have to go back and look at the local country law as well, and the facts and circumstances, because a lot of times countries will have the domestic law which overrides the treaty. So we have to be very, very mindful and careful when we go hire employees in a foreign country to understand the treaty, what the treaty is talking about, plus understand the local country law, because you may hire a consultant or an employee in a foreign country, and that employee could be construed to, if that employee is doing multiple services, it could be construed that you're creating a qualified business unit in the foreign country, and there could be additional filing requirement not only in the US but in the foreign country as well. So make sure that you're doing a proper due diligence, when you're hiring employees. Now, one thing I will say is that whenever you are having a P risk over there in a foreign country and you do your due diligence, you also have to keep in mind that there could be additional filing requirements, as I mentioned earlier, in the local country. You may have to file a withholding tax return, you may have to withhold taxes, and also you may have to file a protective return in that local country where you have hired the employee, but you also may have to file a US tax filing requirements would get triggered. And I would say that one key item over here that I would say, Chris, you mentioned earlier the IT companies. A lot of IT companies will go hire consultants in a foreign country or employees to do the software development, and they do not realize the risk that they're creating for their IP, which is parked in the US, and what kind of risk and exposure their IP will have in the foreign country. So therefore, you should make sure that when you are hiring a software developer in a foreign country, make sure your IP is protected. Proper ring fencing is done by putting some transfer pricing in place, because you do not want a foreign country to come back and say, hey, you had this employee working over here, accessing your server, your network, doing software development under your direction. And therefore, whatever development he has done or she has done in that local country, that IP is the rights of the local country and not the US. So be very mindful that proper IP planning is done around that, proper ring fencing is put in place to mitigate the risk of your IP getting claimed by a foreign country just because you went and hired an employee over there in the foreign country. So just something that Chris, I always tell my clients, I advise my clients to be very mindful of and do proper due diligence around that.
Yes, and the IP is so important, and we run into that a lot. And that can be such a terrible misstep, and it's just an easy fix. And in fact, one of the things I hear a lot from companies is they'll say, "Hey, look, we don't have permanent establishment in another country because we don't have foreign employees. We don't hire employees of our company. And in the U.S., we think of an employee as someone who gets a W-2, and so and then versus someone who gets a 1099, which would be a contract employee. And so I hear this a lot. I hear, well, Chris, we don't have employees. All we do is we contract labor in another country, and so therefore we don't have a permanent establishment. I just want to make sure that's kind of a point that's understood here, the difference. And so Raj, can you kind of speak to, is there a difference on whether this is a quote unquote direct employee, W-2 employee versus, direct contracting of employees with another country?
So whenever you are going and hiring a consultant or an employee directly from the US and you are acting as an employer or giving the salary to that person, that is a direct employee of yours. But a lot of times when a company will say, hey, I want to hire somebody on a short-term basis, and they will probably go and use a third-party firm, an employer in record firm, to hire the employee or the consultant in a foreign country. So once the company uses the third-party firm to hire an employee on their behalf, then that is considered to be a contract or consultant for the US company. But keep in mind that we still have to go back and do the same analysis that I mentioned earlier when you're hiring a direct employee versus hiring an employee using a third-party firm who will act as an employer on record. The same analysis needs to be done because your company that you're trying to hire in that local country to act as an employer on record, when you sign a contract with them, the contract will clearly mention that we will act as an employer on record on your behalf in that local country for that consultant that you're hiring. We'll take care of the withholding taxes and the filing requirement of the employer-employee relationship, but any tax implication or permanent establishment implication is not going to be our responsibility. You will have to go back and talk to your tax advisors. So something to keep in mind always that all the due diligence needs to be done. You cannot mitigate the new due diligence that I mentioned earlier to mitigate the risk of P, but also the IP is very, very important. You want to make sure that even in a model like this, you are protecting your IP, putting a proper ring fencing, even though you use a third-party employer and record firm in the local country. So that's something that you have to make sure that you address that as well, in addition to the P issue. But keeping in mind that I mentioned earlier that you can always hire a consultant on a short-term basis using a third-party PEO firm for 4 months, 6 months, 1 year, depending on what the local country laws are. So you'll have to still reach out to your tax advisor and say, hey, I want this consultant for 6 months, 1 year, or 2 years. You can use a third-party PEO firm. But once you decide that, hey, I want to be there on a longer term, hire more employees in that country, then that's the time you should start thinking about setting up a legal entity. That's very, very important. Otherwise, your risk of IP being claimed by the local country government is much higher. Your risk of a permanent establishment is much higher in the country.
Thank you for that, and I think that's super important, Raj, because I think the understanding of, hey, if you're hiring anyone, in a foreign country, if you're a U.S.-based company hiring anyone in a foreign country, you need to be careful here because the rules aren't the same, abroad as they are within the United States with contractor versus W-2. And to your point, I mean, so a PEO is a great tool, but again, depending on the country or where you are, and many times it's just a short-term tool. It's not a long-term solution, not always. And so, for example, what we see in the DC market is there's a lot of government contracts and also business opportunities for U.S.-based domestic companies to provide services to the government or private companies where the work must be performed abroad. Meaning that we've got a contract here in the U.S. with our U.S.-based company, but the services are being required to be provided in a foreign country. And then depending on that contract, depending on that country, et cetera, the PEO might not be the best tool. And I think you touched on this just a little bit. And so in these situations where there's an outbound company looking to establish, services in a foreign country, this is where the topic of a new entity arises, and I think that this can be surprising to a lot of listeners. And so Raj, can you kind of touch on when it is that we might use or create a foreign entity rather than just using a PEO as we talked about?
Right. So, Chris, as I mentioned earlier, that whenever if you are going to go to a country on a short-term basis with 1 or 2 employees, you can use a PEO firm for short-term, 6 months, 1 year, year and a half. But make sure you do your due diligence from local country perspective. That is that viable, and that could not trigger a P risk, and your IP is protected. But if you think that there is a resource available in that country and you need to hire multiple resources, then the advice is that don't use the PEO firm and start having your own presence in that country. But before you even go to that country to set up your legal entity, make sure you do a proper due diligence and reach out to your tax advisors, your international tax advisors like Bekaert, and talk about that. Hey, I'm planning to go and hire this, 4 or 5 or 10 consultants in the software developers in this country. Is this the best country for me, or should I consider any other country? Because going and setting up operations in or legal entity in any country is easy. It will take time, anywhere between, each country has different rules. But what is my exit plan? Let's say tomorrow you're not successful. You should have a proper exit strategy to get out of the country. And I'll give you one example right now, Chris. We are helping a client right now. They want to set up some operation in Middle East and also a back office, in somewhere in the Asian market. So what I've told my client is, let's try to first understand that which of the Middle East country is good to set up your legal entity and do your sales and marketing to expand your operation. And then also which Asian country is good to hire consultants to do your software development. And that feasibility study will cover a couple of things. One is the local country laws, the treaty that the US has with that country, whether it's a good treaty or not. If there is no treaty, then should we put some kind of a blocker, a treaty country blocker in between for your sales and marketing and expansion in the Middle East? And the second thing, on the software development, we have to see what is a good treaty network for hiring the resources in the Asian market, which country you can find the resources, what is the good exit plan from that country, and what is a good treaty network from that country. So that is something, key thing that you should start thinking about. And the reason why I bring up the exit plan, I bring up the treaty, because under the treaty, you just want to make sure that when you expand in that country, you will be making profits in that country because you're going to be doing sales and marketing. You'll be hiring software development in the Asian market to do software development, and there will be a cost plus markup transfer pricing that we will put in place. But what is going to be my repatriation strategy of the cash of my profits or my dividend from that country? And therefore, treaty network is equally important for you to analyze that. Can I get a lower withholding tax or a zero withholding tax when I bring my profits back, my dividend back, or even if I'm sub-licensing my IP to use for customers in the local country, let's say Middle East, then what is going to be my royalty payment and the withholding tax around the royalty payment? Can I use a treaty network country to minimize or lower my withholding tax? So that is very important for you to consider. In addition to that, you also have to make sure that you have a very tax efficient structure on your global operation, and your overall global effective tax rate is minimal when you're expanding your operation from outbound or inbound perspective.
Yeah, and I think that those some new terms there, exit plan, dividend repatriation, and treaty. I mean, those keep popping up, and I think we'll hear them again when we go to the outbound. And in fact, I think that they're so important that if there was a test after this, I would be nudging the listeners to say, hey, we may want to make sure to listen up when you hear exit plan, dividend repatriation, or treaty. So to our listeners, as you can tell, we have a lot to cover here. So we're going to end this particular episode and pick up with the second episode, which will cover the inbound piece of the transactions and issues. Be sure to stay in for that. And in the meantime, if you have any questions for international tax planning for your business, feel free to reach out to Raj or Cherry Becker or myself personally. You can contact our team anytime. You visit cbh.com/iTax to learn more. That's cbh.com/iTax.